Um, record should reflect we've had a lengthy bench conference in this matter. And Mr. Brown brought forth the point that this case, in some form and or another, was previously adjudicated at preliminary examination in June, and the case was dismissed. When I say the case, I guess I'm talking about the factual circumstances of this case, because it was then reauthorized against this individual. This case, then this one then coming. What happened on the reauthorization is that a count was added. We had, I don't know how many attorneys up here trying to clarify what was added and the basis for it. As I'm to understand, so that the record is clear, the basis for the reauthorization was new evidence. That might be a basis to reauthorize a case if it were truly new evidence. Upon questioning by the court, the prosecutor that reauthorized it indicated that the new evidence was the body cam footage from the police agency, which existed at the time of the original case. And that I don't know under what definition of new that even falls, but that the case was previously dismissed because there was conflicting testimony as to whether or not the backpack was blue or whether it was black. They went back to look at evidence which was already in the possession of the, or available, I should say, to the people, of the color of that backpack, determined the color, and then brought this new case against this defendant. The reality is, don't care how you dice it, slice it, cut it, that's not new evidence. That's just evidence that wasn't looked at by the people at the time of the original case. And quite frankly, I probably would have had a lot more to say, but we got a lot here today. But I will tell you that I told the prosecutor, and I'll make it very clear, that is not new evidence. It shouldn't have, this case should never have been reauthorized, because it's not even really a reauthorization, because it's really a nothing. This defendant should not have been before this court on this charge, had to go through that entire process. This witness should not have had to be here. They should have just admitted to their mistake from the very beginning, just called it and said, we blew it. They blown it. This case is previously dismissed. This one, albeit a reauthorization, this court is ordering that it is dismissed, and these charges are dismissed against this defendant given what's happened with prejudice. Sir, you may step down. Thank you. Okay, so the people of the state of Michigan versus Jeremy Shue.
Al Chemilowski for the people.
Good morning, R.J. Kill on behalf of Jeremy Shue. Jeremy, would you state your name for the record?
Jeremy Shue.
Thank you.
Your Honor, today we adjourned one of the R&O charges against Mr. Shue because we didn't have a medical. I'm not sure we still don't have the medical, but that being said, in the interim, Mr. Shue wrote a 2-page letter to me basically saying that I should be disbarred. He refused to see me at the jail. So obviously there's been a breakdown in attorney-client privilege. He has every right to be represented by an attorney who obviously doesn't want me. I'll leave it in the court's discretion. I'm asking to be withdrawn.
That's me, sir.
Go ahead, Jeremy.
Your Honor, Mr. Killaw was substituted by Ms. Freshour due to two things. One, Mr. Killaw.
What do you mean substituted by?
Judge, there were 4 traffic offenses I was also pointed on with Judge Freshour. And in my conversations with Mr. Shue, I filed a motion for Judge Freshour to recuse himself, which apparently didn't sit well with Mr. Shue.
Again, I'm sorry.
No, I just had to get clear what you were telling me because I didn't know.
I was trying to tell you, but Mr. Killaw cut in.
Well, no, I asked him, Jeremy, to explain it to me. So
what I was gonna, tell Your Honor was Judge Freshour, substituted Mr. Kilowog for Mr. Elman, or Bob Elman. However, due to Mr. Kilowog not coming to see me, I still haven't got no medical records from the prosecutor, which that's a violation.
Well, hold on, Jeremy. You're jumping ahead because what I understand is they don't have them. Yeah, it's not like, hold on. Got to quit being so suspicious, right? If the prosecutor had given them to Mr. Kilowog, there's not a doubt in my mind he would have gotten them to you because that's what we've been waiting. So you're jumping ahead. You're getting suspicious, like somebody's trying to withhold something or denying you your rights. If it's not there, that may work to your advantage. But well, now you understand. But you were about to go off on something. So yes, you were. Go ahead.
Mr. Kilowog filed a motion without my knowledge or without my input to Judge Freshour that was perjured, saying that I filed legal action against Your Honor. Ms. Freshour didn't really care for that when I explained to her that Mr. Kilowog, I have documents.
Well, hold on. You got to slow down because I'm not there, so you got to explain it to me. Okay, so Mr. Kilowog files a motion. What was it? A motion to recuse?
Correct.
And saying that you had filed something against Judge Freshour, like a grievance or something?
No, it was legal action against Judge Freshour. As of yet, I haven't pursued the last domestic violence that was falsely charged as of today. There's also other great.
Well, hold on, just hold it. So you're saying that Mr. Kilowog made some statement that was false in that motion? Okay. And the statement you're saying is what?
That I filed legal action against Judge Freshour, which as of today I have not.
Okay, but you were anticipating that you might do that.
Yes, I am.
Okay.
Prosecution.
Okay, all right, I got you. Okay, so let me just stop you there, and I know you got more to tell me. If Mr. Kilowog knew that you were contemplating it, then him making that statement would be a proper statement to make to the court. Okay. So again, I think you're jumping ahead saying he's filing something that perjures or whatever, but he would, and in fact would be protecting your right by doing that. Okay. All right. Go ahead with your next part of your conspiracy.
Due to as of to date, we haven't had no discovery in either of these matters. As of to date, we haven't got the police report, or not the police report, but the camera. What the other Scott shares were entitled to have the camera.
And Jeremy, you're going to start quoting law to me now.
I'm sorry, sir. I'm
Jeremy, how long have we been dealing with each other?
long time, sir.
Yeah. You think I know the law?
Yes, I.
Okay, but go ahead. I'll let you talk.
The other thing is, in the domestic violence allegation that was falsely charged and rightfully dismissed, it was Prosecutor Jessica Blanche made a comment stating that I would not be charged with these R&Os had I completed a treatment program in that domestic violence case. The domestic violence was ultimately dismissed. The probation violations was ultimately dismissed. So that threat for a vindictive prosecution raises another issue, which we need to transfer from that domestic to show that it's a plan. If Mr. Kilowog would have bothered me.
Well, but hold it, Jeremy.
I understand I'm getting ahead.
Yeah, you are. So you're saying that the prosecutor made a statement that if you completed some type of batter's intervention or domestic violence program.
It was a dual diagnosis program in Saginaw, which due to my
Yeah.
wheelchair and all that stuff, I wasn't allowed to attend that program. And Judge Conlon ultimately dismissed the probation violations
Okay.
due to the ADA violation of the program itself.
All right.
As of now, I sat in jail. I was out there doing what I needed to do. I was threatened by the prosecutor and falsely charged domestic, where I did 4 months for misdemeanor. The domestic was dismissed. The witness intimidation was brought up, ultimately dismissed.
Okay, Jeremy, I'm going to stop you again. All of that may have happened. I'm not understanding what that has to do with what's before me.
I understand, sir. It plays into the vindictive prosecution of this case that we're setting here. And now, in the police report, they state that there was medical records. However, one of the reasons Mr. Kilwall, our communications had broke down is because he gave me, with the prosecution knowledge and coming from the prosecution office, gave him, obviously, he gave me personal information, sergeant victim, of the last time he was here. When I brought it up to Mr. Kilwall, that he gave me the address, the phone number, social security number, the driver's license number, and everything. He told me to hang on to it. He basically blew me off.
Judge, I got to stop right here. There's no way I told this gentleman to hang on to that stuff, okay? And I've been listening to him patiently. I tried to see him a couple times. He refused to see me. The one time he did, it lasted 30 seconds. He turned his wheelchair around, said, "You're fired." So he can talk all he wants.
Anyways, he gave me documentation. I had to bring that documentation up to a sergeant at the jail on camera and give him that documentation because I felt that I was being set up for another witness intimidation case, which the officers involved in these matters, I have no hostility towards. I don't have no ill will towards. I don't mean them or their families any harm. I'm not a violent person. I was outside of jail doing what I needed to do. I had that information. It was like, how did this information get from the prosecutor, Mr. Kilowog, to me?
Okay, all right. So Jeremy, hang on a second. Let me assume for the sake of argument that what you're saying is true. Okay? Let's say the prosecutor turned this over to Mr. Kilowog. Mr. Kilowog gives it to you. Let's just, for the sake of argument, I don't know that it happened that way. I don't think necessarily it would. You say something to Mr. Kilowog. Mr. Kilowog goes, "Well, just hang on." Okay? That's what you're telling me. So the conclusion, hold on. The conclusion you jump to is that Mr. Kilowald is some part of some conspiracy to do that to you, right?
Yes,
Okay, Mr. Jeremy. I'm going to tell you you're wrong. Absolutely wrong. I've known Mr. Kilowald 25, 30 years. He's a good attorney. He's a great attorney if you just listen to him. All right? There is no way ever that he would ever do something, the prosecutor, let alone anybody else, that is going to forsake his client. It would never happen. And that's why Jeremy, I'm telling you, the conclusion that you're coming to is the wrong conclusion. Because with that man, that will never happen.
I understand but from the actions that I'm.
Hold on, Jeremy, but you're jumping to a lot of conclusions about a lot of stuff. All right? And I'm just telling you, and Jeremy, as long as we've been dealing with each other, I tell it to you straight. If I thought Mr. Kilowog might do something like that, I'd say, okay, well, whatever. But I'm telling you, he'd never do that. Ever. It does, okay, but Jeremy, what if you say something to him, he misunderstands what you're telling him and says, just hold on to it?
That could have been possible.
Okay, then Jeremy, I'm saying if that's possible, quit jumping to the negative. I'm telling you, jumping to the negative with this man here is just wrong. So Jeremy, what do you want me to do? Because my understanding is we were waiting on medical on this case. Right. And so maybe, Jeremy, if you talk to your attorney, maybe there's something else that's going to happen.
I'm willing, if you would like to hold off on this, I'm willing to speak. It hasn't came up.
Okay, but Jeremy,
Sorry.
Jeremy, maybe he hasn't come to see you because you don't act right. Jeremy, don't even try with me because sometimes, even though you're on my docket, I don't want to see you. Okay? So now, Jeremy, I'll ask you this. Do you want me to hold the motion that Mr. Kilowald has raised in abeyance, send you back, give you an opportunity to talk with him, and talk with him?
Yes, sir, I will do that.
Okay. Jeremy, when I say talk to him, what do you think I mean by that?
Listen, no talk.
Wow. Well, you actually learned something today. All right?
Try to learn.
If you and if you don't understand something, don't jump to the negative like you did with everything you just told me here. Just if you don't understand something, ask the man. Just okay. And you don't listen to that either, do you? No, you don't. Don't even. You started trying to talk, and you know what the answer to that is. You don't listen. So here's what I'm going to do. I'm going to pass this matter. They're going to take you back. They're going to get you out. I'm going to hold Mr. Kilowald's motion in abeyance. You're going to talk to Mr. Kilowald. Jeremy, you're going to talk to Mr. Kilowald. You're going to listen to him. Jeremy, if I believe this man would ever lead you astray, I'd get you a new attorney. He's not going to lead you astray. He's going to give you the best advice that he can, and he will fight for you. Got it?
Yes, sir.
All right, we'll call you back up in a bit. Court recalls the case, people of the state of Michigan versus Jeremy Shue.
For people.
Good morning, I'm Rob Jacob on behalf of Mr. Shue. Jeremy, would you state your name? Judge, Mr. Shue, he and I have had a nice conversation.
We're shocked.
Well, he's promised to let me see him at the jail. There's been an offer made on partial offer made. We have to confirm if there's going to be a second or a complete offer made. That all being said, can we adjourn this till the 17th?
That good with you?
Yeah, yes, sir. I'm playing. You keep playing with me.
I'm playing with you. What do you mean I'm playing with you?
No, I understand. I'm being sarcastic.
Okay.
That's great.
And he's going to let me see him at the jail, and we're going to talk about it, and hopefully we'll have this matter resolved when we come on the 17th.
Sure.
It's amazing when you just take time and talk with somebody. I tell you, he's not going to let you down.
Don't promise too much, Judge.
No, you need to let him down. I know if something bad happens, it's not because he didn't try.
His name ain't Brian Linden or Jeffrey Pfeiffer.
Well, and maybe that's good.
Okay, so
17 in person.
okay.
Jeremy, we'll see you then. All right, take care.
Your wisdom is correct, at least for today.
Excuse me?
Thank you very much.
My wisdom is long lasting.
I hope so. I may be calling you from the jail. All right, thank you.
Take care, Mr. Kilowald.
In this extended courtroom proceeding, the court first addressed a case that had previously been dismissed at the preliminary examination stage in June. only to be improperly reauthorized by the prosecution under the claim of new evidence. After a lengthy bench conference, the judge made it clear that the so-called new evidence police body camera footage had existed at the time of the original case and therefore did not legally qualify as new evidence at all. The judge expressed strong frustration, stating that the prosecution had simply failed to review its own evidence earlier and had refiled the case based on that oversight, forcing the defendant and witnesses to endure unnecessary proceedings. As a result, the court dismissed the reauthorized charges with prejudice, making clear that the defendant should never have been brought back before the court. The court then moved on to People of the State of Michigan v. Jeremy Shue, where defense counsel requested to withdraw due to a complete breakdown in the attorney-client relationship, citing accusations, refusal to communicate, and a 2-page letter demanding disbarment. Mr. Shue voiced numerous allegations, including claims of vindictive prosecution, conspiracy, withheld discovery, false statements in motions, and misuse of personal information while repeatedly jumping to conclusions and expressing deep mistrust of his attorney. The judge firmly but patiently addressed each concern, repeatedly correcting Mr. Shue's assumptions, explaining that his attorney had acted appropriately and ethically, and emphasizing that speculation and suspicion were undermining his own case. The judge strongly defended defense counsel's integrity, noting decades of experience and stating unequivocally that there was no conspiracy and no misconduct. Ultimately, the court held the attorney's motion in abeyance, directed Mr. Shue to speak directly and calmly with his attorney, and reminded him that meaningful progress could only happen through cooperation and communication. After the case was recalled, defense counsel confirmed that constructive discussions had taken place, a partial offer had been made, and further negotiations were possible. The court adjourned the matter to October 17th, expressing optimism that the case could be resolved if dialogue continued, while reminding Mr. Shue that listening, rather than assuming bad faith, would serve him best moving forward. For more information, like and subscribe my channel.
Is Ahmed, is it Enrinrich, right? Probably said that wrong.
Alex Chavalowski for the people.
Mr. Overwater.
Sorry, Your Honor, this is Ken Overwater, Assistant Public Defender on behalf of Mr. Ehrenreich.
State your name, sir. Mr. Ehrenreich.
Can you state your name for the judge?
Yes, my name is Amit Ehrenreich.
Okay.
At the same time,
All right.
I do not have anyone representing me.
You don't?
No.
Okay, you
No,
don't want somebody representing you?
I will be representing myself, Your Honor, if I may.
Have you discussed that with Mr. Overwater of the Public Defender's Office?
I have not. I do not know Mr. Overwater.
Your Honor, if I may, I went to the jail yesterday to meet with Mr. Ehrenreich. One of the deputies brought him to the cell. He looked at me, and evidently he told the deputy he didn't know who I was, so he refused to meet with me. The deputy tried to encourage him to sit down and talk to me. He continued to refuse to do so, and then he left. Based on that, the information that I was given by the deputy I spoke with, as well as the allegations in the police report, I'm concerned that there may be an issue of competency. Obviously, I have not been able to speak to Mr. Ehrenreich, so I cannot verify that independently. What I was planning to ask for is for the court to admonish Mr. Ehrenreich to at least consider speaking to me and to adjourn the probable cause conference for that purpose. If he is resolute in his intention to represent himself and to refuse to speak with me, then I would leave it in the court's discretion.
If I might jump in, Judge. Torshio Feaster, Assistant Public Defender. Judge, I did represent Mr. Ehrenreich at a probation violation, a PPL violation, about a week and a half ago. So he does know who I am. And at that time we spoke, he said he wanted to represent himself on the PPL violation, but he did want our office to help him on the new felony charge. So maybe he didn't speak to Mr. Overwater because he did not realize he's with our office. But I would, on behalf of Mr. Overwater, I think, ask for an adjournment and ask our client, please speak to him about this matter moving forward.
Mr. Ehrenreich?
Yes, Your Honor.
Did you hear Mr. Feaster?
I heard partially. One of the guards was speaking on his communication device, and I could not really hear what was going on.
Oh, okay. You had a hearing in circuit court on a PPO violation?
That is correct, Your Honor.
Okay. You remember the attorney that was representing you at that hearing, Mr. Feaster?
I do remember Mr. Feaster, and I believe the judge was Mr. Conlin, if I'm not mistaken.
That's right. Okay, that's right. So Mr. Feaster stepped in.
I cannot hear.
Can you hear me, sir?
Yes.
Okay, Mr. Feaster just stepped in right now to let you know that Mr. Overwater, who you wouldn't speak to, that they're part of the same office. So you didn't know who Mr. Overwater was when he came to talk to you, but he and Mr. Feaster work in the same office. And I don't know if you were aware of that or not.
I understand what you're telling me, Your Honor. I understand. I was not
Okay.
aware of that.
Okay. So here's what. Go ahead.
At the same time, Your Honor, I would appreciate at this point representing myself.
Okay. Here's what
I will mention, Your Honor, that at the circuit court, I spoke very clearly, and Judge Conlin, for whatever reason, postponed the discussion. He didn't want to hear what. I'm not exactly sure. Bless you. I'm not exactly sure what went on. I admitted to having gone to that street where that person lives.
No, Mr. Eckenwright, please don't say anything about the substance of the case. Anything you can be used against you. So please don't say anything like we discussed last time. Please wait and speak to Mr. Overwater and let him try to help you. You're facing a 5-year felony.
Mr. Ehrenreich, if you don't understand what happened in court, it might be because you need the assistance of an attorney.
All right, Mr. Ehrenreich, here's what I'm going to do. I'm not going to rule on your motion right at this moment to represent yourself. What I want you to do is talk to the public defender, and after talking with the public defender, you can make an informed decision as to whether or not that's what you want to do. Okay? So I'll hear you out on it. It's just that I'm not going to hear you out on it today. I want you to talk with them and make sure that you're clear on where you're headed with this. Because it sounds like there's a lot that you're dealing with in terms of the PPO violation, this case, and it could carry some severe consequences. And I just want to make sure that you talk to somebody before you make that decision. All right?
Your Honor, I appreciate what you're telling me, and I understand everything clearly. At the same time, I have done almost nothing. I do not understand why what I did not hurt a fly. I did not.
Okay. All right.
Mr. Ehrenreich, I don't want you to say anything about the facts of the case. I will explain what happened and why you're in jail, what you're charged with. I'll explain everything to you if you will let me meet with you.
I do not wish to meet with Mr. Overwater, with all due respect to him.
Okay. All right. So, Mr. Ehrenreich, let me ask you this. You met with Mr. Feaster, correct?
I've had a video conference with him. I have not met with him in person.
Okay. All right. So I don't know, and I'm not going to interfere on who's going to meet with whose cases are assigned. The public defender's office now knows that. So it might be Mr. Feaster that you meet with. Okay. But in any event, particularly given what you said, that you're not sure why you're there or anything else along those lines, I want you to meet with an attorney that can explain that to you. All right. And then you can make the decision as to whether or not you want to go forward and how. Okay.
Your Honor, I understand the situation completely.
Well, no, you don't, because you don't know what you did that has you where you are. And you just said that to me. So you don't understand it all. And I've got to make sure that you do. And one of the ways I can make sure that you do is to have you talk with somebody so they can at least explain why you're where you are right now. Okay? And that's so, Mr. Ehrenreich, I'm going to do that, and I'm going to do it to protect your rights. So I'm going to tell you that when they come down to talk with you, I need you to talk with them at least, okay? And then we'll come back, and then you can make your decision about what you want to do.
Your Honor, I respect everything that you say. At the same time, I do not wish to waste anybody's time. And from my point of view, I'm willing to proceed. I know exactly why I'm in jail. I know what I've done. I know what I didn't do.
You just told me a little while ago, Mr. Enright, you didn't know.
No,
and now you're telling me you know. That leads me to believe that I may have to order a competency on you. I don't want to do that. Okay? Mr. Ehrenreich, I'm going to implore you to speak with an attorney first. Because you're telling me one thing, then you're telling me something else. And that may lead me down a path that I don't know that you want to go to or go down.
It says the connection is unstable. I'm not exactly sure, Mr. Gibbs.
Still hear you.
Okay. Your Honor, can you hear me?
I can hear you.
Oh, all right. It just displayed the connection is unstable. I just want to be very clear on what I said in order to avoid any confusions or misunderstandings. I know wholeheartedly why I'm in jail. I know what I've done. I'm willing to hold myself accountable. I'm willing to hold myself accountable for what I've done. The thing I do not understand, and that's what I meant when I communicated that, I do not understand how what I've done is got to a point where I feel felony is being...
Mr. Ehrenreich, that's the problem. That's the problem. You need somebody to explain what, if you're saying you did something,
yes,
and I don't want you to say what you did. If you said you did something, but you don't understand what the consequences of that are, that's a problem. And so I'm going to get an attorney to you. I'm going to ask you to speak with them so at least they can explain that to you. Then you can make your decision about whether you want them to help you and represent or whether or not you want to do it yourself. But Mr. Ehrenreich, I'm done. That's what I'm going to do. It's up to you now to talk to the attorney so that you have as much information as you want. If you don't want to do that, you might want to tell me now so I can order a competency.
I rather represent myself. I rather not speak to an attorney. I do not feel that competency is needed. However, if Your Honor, if you would like to do that, it is up to you. You're the judge.
Oh, I am. So here's what I'm going to do. I'm going to order a competency a forensic evaluation, given what I've heard from the defendant on the record and what apparently is a confusion on a number of different levels. I'll set that competency hearing for.
You want to do 60 or 90?
60.
Tuesday, November 21st.
That'll be set for Tuesday, November 21st. November 21st, 2023, 9 a.m. Mr. Overwater, can you please prepare the orders for the court signature, please?
I will prepare that order. Thank you, Your Honor.
Thank you. Court calls the case. People versus James Lyle.
Nimish Ganatra, First Assistant Prosecuting Attorney for the People.
Ready, Judge. Portia Feaster, Assistant Public Defender, on behalf of Mr. James Lyle. Mr. Lyle, please state your name for the record.
James Lyle.
Thank you, Judge. Mr. Lyle, as you can see, is an MDOC. I never like to start your day off poorly and to make you upset early, Judge. But I've called MDOC to try
Oh,
to
you wait till later in the day to do that, right?
Yeah. We're almost done, Judge. Well, this is very early today to bother you with this. But I've called MDOC to speak to Mr. Lyle per their policy, and I have not been able to reach him, Judge. So I'm going to need to either ask for an adjournment or for a breakout, Your Honor.
Man.
Your Honor, I just
Yes.
have one question.
Sure.
Is Mr. Feaster wearing a camel hair coat today?
I am. Thank you for noticing.
It's not October. Wow. This is a bold move for you.
Thank you. It
looks good.
I appreciate
it. I'm glad we're all together in this. All right, Miss Weidling.
Yes, sir.
With much regret, but because of what he's wearing today, could you put Mr. Feaster into a breakout room with Mr. Lyle, and I'll pass the matter.
Thank you, Judge. I'll be brief.
And he gets nothing else today. Versus Devon Jenkins Jackson.
Nicole. Sandra White on behalf of Devon Jenkins Jackson for the motion.
Yes, go ahead with your motion.
Yes, Your Honor, I brought a motion in order to withdraw on this matter due to a conflict.
Okay, there's a well, you have a conflict of what nature, counsel? Because it doesn't say.
It should say in my motion.
It just says has a conflict with representation of, but doesn't lay out what that is.
Oh, I'm so sorry. I thought it was in there. I'm going to work with the public defender's office.
Oh, really?
Yes, aren't they lucky?
I didn't say all that. I just said, well, congratulations to you. That's fantastic. Mr. Jenkins Jackson, do you understand that, sir?
No, I don't understand what she said.
We have spoken about it several times. I'm sorry, Mr. Jenkins Jackson.
Oh, that she went to the public defender's office and can't.
Right. The public defender's office originally withdrew on your case. Ms. White is going to join the public defender's office. So you'll need to, new counsel will need to be appointed for your case. You understand that, sir?
Yes, sir.
All right. So I will sign the order allowing withdrawal, and I believe Office of Manage Assigned Counsel, I'll call it what I think it is, has appointed Sydney Rushing to represent you. And I believe she's here.
Good morning, Judge. Sydney Rushing, appearing on behalf of Mr. Jenkins Jackson this morning.
All right. All right. And what are we going to do in this case? You're probably going to want an adjournment.
Yes, Your Honor. I would love an adjournment this morning. That way we get discovery and I can have connection with Mr. Jenkins Jackson.
All right. Probable cause conference without objection in this matter will be adjourned October 12th, 2023, 9 a.m. Bond continued. All right.
Thank you, Your Honor. Have a great day.
You too.
In this extended court session, multiple matters were addressed, beginning with People v. Aaron Wright, where confusion immediately arose over legal representation. Mr. Wright initially stated he wished to represent himself and refused to speak, with an assigned public defender claiming he did not recognize him. Defense counsel informed the court that Mr. Wright had refused a jail meeting the previous day, raising concerns about competency, especially given the seriousness of the pending felony charge, which carried potential prison exposure. Another assistant public defender clarified that Mr. Wright had previously accepted representation from the same office during a recent PPO violation hearing, suggesting the refusal may have stemmed from misunderstanding rather than intent. Despite repeated explanations from the judge emphasizing the importance of legal counsel, Mr. Wright continued to contradict himself at times, stating he did not understand why he was in jail, and moments later insisting he fully understood and accepted responsibility. The judge carefully warned that these inconsistent statements could necessitate a competency evaluation, stressing that self-representation without understanding legal consequences posed a serious risk to Mr. Wright's rights. When Mr. Wright firmly refused to meet with any attorney and continued to vacillate in his explanations, the court ultimately ordered a forensic competency evaluation, setting a competency hearing for November 21, 2023, to ensure the defendant was mentally capable of proceeding and protecting his constitutional rights. The court then moved on to People v. James Lale, where a brief procedural issue arose due to difficulty contacting MDOC for policy clarification. The judge ordered a breakout room consultation between counsel and the defendant, injecting a brief moment of levity before passing the matter. Finally, in People v. Devin Jenkins Jackson, defense counsel requested withdrawal due to a conflict after accepting employment with the Public Defender's Office. The court approved the withdrawal, appointed new counsel, and adjourned the probable cause conference to October 12, 2023, allowing newly appointed defense counsel time to review discovery and consult with the defendant. Throughout the proceedings, the judge repeatedly emphasized fairness, procedural clarity, and the protection of defendants' rights while maintaining firm courtroom control and ensuring each matter was handled appropriately within the bounds of the law. For more information, like and subscribe my channel.